Hello, and thank you for joining us today. For those joining us online, thank you so much for being here. We are here today to speak all matters data protection, and we hope that this discussion will be interesting and useful for you. We will have a panel joining us after this. I'm going to do a little presentation on the paper that we just launched at Access Now, and then after that, we're going to have a panel joining us on stage to speak about some issues on implementation in the region. And after that, we're going to have a chance for you guys to ask a few questions that you may have. So let's kick it off. So as we thought about this paper, initially we were going to, just to give you a little bit of history of how this paper came to be, we were going to do, the boring old analysis of laws or comparative analysis or whatever it is that so many people have done. But then we realized that so many people have done this before and they've done it really well. So there was no reason for us to do it again because it's already been done and it's been done thoroughly. So then we looked at data protection in the region and we realized that there was a conversation to be had about implementation. And of course, then we don't claim that this paper covers everything that has to do with implementation and data protection in the region, but we picked out a couple of key issues that we would like to talk about and we would like to start a conversation on. So, just to talk a little bit about data protection, first of all, of course, 35 countries in this region have data protection laws, which is really awesome. Something that I found out that I actually did not know, shame on me a little bit, I'm sure a number of you know this already, is that Cape Verde was the first country to have a data protection law all the way in 2001 was it? And so it's been in existence for a very long time. But now there are 35 countries that have laws, with 3 draft laws also being in the pipeline for Ethiopia, Namibia, and Malawi. And you can see a little map over there with some of the countries that already have laws. Some of them, the orange is countries that have draft laws. And of course, the red is countries that do not have laws. But I think we're doing pretty well for a region. So, of course, we were having a very interesting conversation right before we started this event on the Malabo Convention and whether or not it would be useful for us as a region. But either way, that remains a question for some of us to have in the minds, and it remains a conversation to be had on the usefulness or, for implementation on this region of data protection, whether or not the Malabo Convention continues to be ratified or adopted in member countries of the AU. But as it stands, there are 15 countries that have ratified it, and thus it has come into force this year. But one of the things that we keep asking ourselves, and especially as members of civil society, is why do we have data protection in this region, data protection laws? And as I've written in the slide, this is a matter of opinion. For me, it seems as if we have data protection laws only because there are so many things that are happening with regard to digitization. And the more we ask questions about people's personal data and the safety of their personal data and what has been taken into consideration before digitization efforts are happening, the more we get data protection laws. So it seems as if it's a checkbox exercise for most countries. And to us, it seems as if a lot of authorities have not taken into proper consideration why we need data protection laws. And this is why we have so many issues of implementation when it comes to this region. It's not necessarily a priority. It's more of an enabler of other things. And so if we think of it in this way, it becomes a little bit more difficult for governments and authorities that are supposed to be implementing them to take them as seriously as they're supposed to. So some of the key issues that we're looking at include exemptions. When you look at most data protection laws in this region, and not just in this region, but all over the world, that countries that have data protection laws, there are exemptions in place. So most of the exemptions that exist, at least in this region, from what we've observed, are security agency exemptions. National security, public interest are some of the exemptions that we keep hearing over and over again. But the reality is that whenever we have exemptions like this, and especially exemptions that have to do with national security, it can be a problem in the context in which they exist, especially because they're not very specific as to in what way these exemptions apply, in what way they can be applied, who is subject to these exemptions, to whom these exemptions can apply, and just basically how these authorities can utilize these provisions in the law to their own advantage. And so, again, one thing that we like to remind people is that laws and frameworks don't exist in vacuums. And so you look at Kenya, some of the examples that we've used, even you will find that there are case studies in the report that we've just put out. And for instance, in Kenya, there's the Statute Law Miscellaneous Amendments Act of 2020, which gives powers to the CS of Interior to access data from any phone or computer. And so again, how they access this data, personal data, sensitive data on our devices is not subject to a very large extent to the data protection law. Once again, the debt strategy for 2024-2025 proposes making the Revenue Collecting Agency, KRA, exempt from Data Protection Act provisions. They already have a lot of access to our personal data, don't they? So then making them exempt to the data protection law is something that we have to constantly ask ourselves, what is going to be the effect? We do not know this at this point because, again, it's just a draft strategy. But if it comes into force, what's going to be the effect? Especially since, again, there's no specificity as to how these exemptions are supposed to be applied. An interesting conversation that we've been having is the concept of privacy versus the concept of data protection. A lot of the time when we're having privacy conversations, especially when we are marking it as a gap, whenever there are digitization efforts, we're told that there's a data protection law. But is that enough? Probably not, again, because privacy is not the same thing as data protection. We could argue that data protection is a child of privacy, but it's not the same thing. And, you know, even when you look at some of the, you know, jurisprudence that we have already declared, and we have some of the frameworks coming in or declarations from the UNHRC, there's something like bodily autonomy, for instance, when we are talking about digitization and digital ID. If you take my biometrics, there's a, you know, and I cannot access any government services without my biometrics being taken. What effect does that have on my bodily autonomy, which then begs into, you know, draws us into the privacy conversation. But data protection in itself is not a catch-all for privacy issues, and it should not be used as such. The more we continue to use data protection laws as the answer to privacy concerns, the more we're exposing people to real life risks. The other thing that we looked at when we were kind of going through this paper and doing our research was substantive independence and international recognition of DPAs in the region. So a lot of data protection laws, you look at them and you'll find that the DPAs that are conceptualized under these laws are supposed to be independent. But then when you come in closer to the reality, they're not necessarily independent substantively or, you know, in the way that they function. And some laws actually don't have it in them that these DPAs are supposed to be independent. But even the ones that do, for instance, if you come to Kenya and you look at the independence of the Data Protection Authority, you'll find that, one, the budget falls under the Ministry of ICT. Same thing in Uganda. So if your budget is controlled by a particular ministry who is also the appointing ministry and has some powers with regard to the running of this DPA, how much independence can you truly have? And the other thing that we kind of have to look at is how they respond to certain issues that are within the public domain. Digital ID being one of them, the whole saga with the ORPP a couple of years ago, how did they respond? In Ghana, same issues with digital ID. How are DPAs responding to real life situations that speak in certain ways? And we can kind of extrapolate how much independence do they have when it comes to their functioning, their day-to-day functioning. And then the other thing is, of course, international recognition. This is a problem not only for data protection agencies or authorities. For instance, one of the examples that we kind of drew on was the WorldCoin saga that, you know, rocked Kenya a couple of months ago. And by Tech for Humanity's own admission, the DPA asked them to stop processing. And then they wrote a letter and they said, if you don't respond to this letter, we're going to continue processing. I would like to challenge us to think, in what other country would this be acceptable, especially in countries outside of the global majority? In what world is this acceptable rather? That companies can come in, say, okay, we're going to write you a letter, and if you don't explain why we need to stop processing, we're going to keep processing. Because again, when tech companies come into the global majority, and this just speaks kind of to the sort of colonial thinking that some of these companies have, that they come into these regions in the global majority and they basically do whatever they want because they think there's no real consequence to some of the things, to some of the laws that we have here and the way they're implemented. So that's not necessarily, of course, a DPA problem, is it? It's more of, you know, a tech problem, a tech company accountability, transparency problem that we need to address. And then the last thing that we looked at was automated decision-making systems versus data protection laws. Now, as ADMs take even more of like a hold in this region, we need more than ever to have robust laws and robust protections. And a number of data protection laws cover some of these issues that will come about as a result of these ADMs, which of course are sometimes referred to as AIs. But at the end of the day, we have to keep questioning whether there's something more that can be done. Is it just the data protection laws that can serve as a buffer between the harms that ADMs can perpetuate in this region? And especially because we've seen how ADMs function, not just in this region, but even in countries that, you know, you would say are more developed, if that's the word that we want to use. There's still people who are falling outside the margins that are even more, you know, placed in places where they can be harmed because of these ADMs. And so as data is being processed, there are many things to be considered, even outside the data protection laws that we have, that some of them do actually have certain protections for automated decision making. And we looked at POPIA and, you know, in our report, and you can read more about that. And we looked at the Kenya data protection law. And in the end, of course, because civil society, we're always told that we complain and complain and we don't give any solutions, we came up with a couple of recommendations. The first recommendation I know is a bit of a shaky one and not very many people will agree, but I think there's some value to recognizing and ratifying the Malabo Convention. Not because it's a silver bullet and it'll help every other law in the region, but mostly so that data protection is a priority in this region and it can be recognized as such and people can have conversations about it. The second recommendation that we recommended that African governments work towards sustainable models for independent data protection offices by amending laws to remove overbearing control of other government agencies and by making substantive provisions for the resourcing of DPAs. So as it stands, again, as I explained earlier, a lot of DPAs, even when they're conceptualized as independent authorities in the law, by substance, they are not. And this is because of how their offices are founded and how they are resourced. So governments need to come up with ways to ensure that this does not happen. The third recommendation is that lawmakers amend data protection laws to make provisions for specificity with regard to exemptions. As we've seen and we've explored at length in this report, exemptions can really harm people because of how broadly they're affected. So we need to find ways to make it as hard as possible for people to circumvent laws simply because of where they sit. And then the other recommendation is that governments institute public registers of where and how ADMs are being put to use, because they need to be transparent and there is a need for accountability in how ADMs are used, especially when we think about the effects that they could have on people's real life situations. And then the last recommendation is that governments exercise caution in investing in ADMs to avoid worsening socioeconomic challenges. I think a lot of the time we hear governments saying, this is great, it's going to make our lives easier, it's going to give you access to social services, access to housing. But then what's the reality? If you implement automated decision-making in, you know, effecting social change, is this what is actually happening, or is it actually exacerbating problems? So we need to pick and choose and be, you know, very intentional about the things that we're applying these simple or simplifying mechanisms to make people's lives easier, and yet we're making them harder. So yeah, that's pretty much a rundown of what our paper is about. We invite you to read it. If you have any questions for us, please feel free to send them through to us. We're going to take a 2-minute break and we're going to have the panel join us in a minute. And then we can start our discussion on implementation in the region. Thank you. Thank you again for joining us. And we have on stage a couple of very important people who are very, very smart and will teach you a thing or two by the end of this panel. So just to start us off, I'd like to go from Mugambi all the way to Victor that way. And I'd like you all to introduce yourselves. Tell us a little bit of what you do in your day-to-day life, what you do in regard to data protection as well. And then shortly comment on data protection frameworks in the region vis-a-vis international standards that they draw from. And then, if you may, give us one model law in this region that you would say we should look to as an example of what a good data protection framework should look like.
Thank you very much, Bridget. So my name is Mugambi Laibuta. I'm a lawyer and a certified information privacy manager operating out of Kenya, Nairobi. And I just completed my PhD writing on adequacy on data protection regulation in Kenya. So it was interesting to see some of the suggestions about the need to be specific on exemptions. And one of the things that I did in my research is to provide very clear-cut provisions or proposals that talk about what should these exemptions look like. Apart from that, I'm also a consultant, consulting on with different kinds of organizations within government and out of government on their compliance process with data protection. And I'm also the convener or the chairperson of the Data Privacy and Governance Society of Kenya that brings together over 450 data governance professionals in Kenya from all sectors, where we talk about the profession and how to build each other. Then on a model law, I think for me, it has to be the Nigerian law, the Nigerian Data Protection Act. And why I say the Nigerian Data Protection Act is that I believe that when they were drafting that law, they took into consideration the gaps that are there in the existing law in Africa. So when you look at the Nigerian data protection law, some of the gaps that practitioners and academics have been identifying was sort of covered in the Nigerian data protection law. I'll rank second the Protection of Personal Information Act of South Africa. The interesting thing, it came even before GDPR, and it has really stood the test of time.
Thank you. And now I feel like you've said everything that we'd have said. But my name is Grace Mutung'u or Bomu. I'm a researcher. My current research really focuses on public data. If anyone is Kenyan, this is data that, for example, is based on eCitizen and the services you're accessing there and what happens to your data after that. If you're Ugandan, it's data or stuff that you access through the National Digital ID program. If you're Ghanaian, I think it's happening. It's a trend right now in all African states that they have some sort of digital ID that is also linked to government services. And so I look at data governance in those kind of projects. And one of the proposed or one of the systems that people will talk about as being put in place in order to govern the data is data protection laws. But as Bridget said, all these laws all over Africa, they are really good until they get to the part about public data, and they say that public data is exempted, or data that deals with issues of public order, public interest, public safety, public security, public health, as we saw, was it 3 years ago? When was COVID? 4 years ago now. All that is exempted. So those are some of the issues that I'm currently working on. On the model law, I would say that you can look at it in terms of the text and in terms of implementation. In terms of text, of course, Nigeria has really done well. You know, they tried to fix all the gaps that are there. Their law talks about, you know, gives a lot of, what is the word, power to the commissioner or the data protection authority to even go out on their own motion and investigate issues even without people having complained. It goes way more than any other country in terms of even collective rights. But in terms of implementation, I would also agree with Laibuta that South Africa is one of the countries where they are really big on implementation. They have regulators, generally, all the regulators try to go out and do their job, try to be as independent as possible from the executive. And so even in data protection matters, as much as their law, you know, has not been, parts of the law have not been in fact, I think they've done pretty well in terms of implementation. But then I'd also caution and say that, and maybe it's something I'll say when we come to even the recommendations part, is that we should be shedding the spotlight on regulators that are trying their best despite the circumstances. We have to remember that a lot of these countries we live in, these African countries, things are complex. It's true we have rule of law, it's true we are democratic, but are we really democratic? There are so many layers to it. So I think we also have to give flowers to regulators who, despite all the circumstances, you know, like the Kenyan regulator would write to a very powerful company and tell them, please stop. Yeah, I have said stop. Whether that is put into practice, that is still another question. And so for that, maybe I'd mention them and say that they are trying their best given the circumstances and what the text of the law is. And let me stop at that.
Well, good afternoon, everyone. My name is Cynthia Chepkemoi, and a data protection officer working in a financial, in the financial sector. What I'd like to actually just shed light on with regards to which regulation or rather model law can we really look into in terms of what we can borrow as Kenya is most of the AU policy frameworks. One is the AU data governance framework, which has really given a very good guidelines on how business and human rights can work hand in hand, and we make sure that we really attain compliance in terms of data protection, because what is really a struggle for most of the people in the private sector is they feel like the data protection laws have come in to hinder business and all that. But then there's only one framework that I've seen in Africa that has really embraced the aspects of human rights and business, and how do we actually balance those two. The second model that I'd really like us to also pay attention to is the digital identity framework for the African Union, because what ails most industries right now is issues of identity theft. So how do we resolve this? Because when you look back, we still hold the old frameworks of identifying ourselves. So you have to present an identity card, a passport, but then we need to have a paradigm shift to digital identity. But at the same time, how do we ensure that this has been balanced with the rights of consumers, ourselves as citizens? Yeah. So that is what say about that.
Hello, everybody. My name is Megan Kathure. I am a tech policy researcher where I research data governance and the impacts of technology in our society from an economic, social, and cultural perspective. To answer your questions, Bridget, one, I think much has been said in terms of the model law. So I agree with the comments that of Kapiyo and Nigeria's Data Protection Act, but 2 points with reference to the comparison of the data protection frameworks within the region. One difference we're seeing is what constitutes personal data or personal information and what constitutes data subject. In South Africa's Kapiyo, juristic entities are recognized as juristic entities are recognized as persons, and persons as to whom informational or personal information can relate to. However, in the Kenyan jurisdiction, the Data Protection Act does not recognize juristic entities as to whom personal information can relate to. However, that pronouncement of the Data Protection Act has been overturned, or rather the Kenyan High Court has made a different pronouncement that juristic entities can be recognized to whom personal information can relate to. We're yet to see whether in either of these two jurisdictions, juristic entities will rely on data protection frameworks to sanction any form of investigation on their companies with regards to data protection. Another comment on the legal frameworks within the region will relate to the case of individual rights and group rights. Current frameworks of privacy and data protection are focused on individuals and do not take into account the growing need of collective protections. If you think about how profiling works, a number of personal data are usually combined with other data sets for inferences to be made. So current imaginations of privacy do not recognize collective entities and the role of social relations in defining the self. So there's a need for group privacy and collective privacy to be recognized in our data protection frameworks in the region.
Good afternoon, everybody. My name is Victor Kapiyo from Kenya ICT Action Network, KICTANet. I wear many hats, but I think I'd say that I'm a human rights lawyer and working at the intersection of, ICT and human rights mostly. And KICTANet works in Kenya and different countries, specifically advancing human rights or human-centered ICT policies in Kenya and across the region. Specifically with respect to privacy, I lead the work on cybersecurity and privacy. So trying to see how our legal frameworks and our policies can be more human centered, so that then we're able to promote human rights in various ICT interventions. With respect to international standards and privacy, I think I would like to celebrate all the 35 or so countries that have put in place a data protection law. 10, 15 years ago, when not so many countries were there, our biggest problem was just, can you just have a law? However bad it is or however good, but just have one. So I think I'll use Grace's words. Let's give flowers to those 35 countries that have actually made an effort to put in place a legal framework. Number two, second set of flowers to the other 15 who have signed or ratified the AU Convention on Privacy, because I think we can't be talking about international standards if we are not actually putting in place regional and national standards in the various flavors that they exist. And I think for the countries that are actually making steps, I think it's important that they actually are role model by actually putting in place those frameworks. The other thing that we're seeing across the countries is that over and above putting in place national frameworks, there are certain commonalities that we are seeing in terms of uniform descriptions and terminologies, which are, I think, slowly being accepted as standards. How we are defining data subject, that we are putting in place principles for data protection. I think those are becoming common, and I think in the various laws across the continent, one of the things we'll notice is that we are starting to standardize, which I think is the first step. Secondly is there are certain things that we're actually also providing for. Many countries are providing for, the establishment of data protection authorities. The level of independence varies, but at least there is a movement towards putting in place those authorities. The other aspect that also we are seeing is that there are frameworks for dealing or addressing cross-border data transfers, which the approaches are different, but at least there is an attempt to address how data can be transferred across different countries. I think the other thing that is important to note is that there are mechanisms for remedies being provided for in most jurisdictions, whether it is in through an administrative process or a judicial process. At least there's provision for remedies for people whose rights are violated, and consequences for breaches. And I think also the other thing that, as I conclude, to mention is movement towards breach notification, because our biggest concern was a breach. So I think the requirements in different laws for data controllers and processors to notify the relevant authorities whenever there are breaches, I think that's also a good step that we are seeing as best practice that is emerging across different countries. Thank you.
Thank you all very much for those introductory remarks. As I said, these people are very smart. Those were only introductory remarks. So as Victor has said, and this leads us to kind of the next part of this discussion, we must give flowers where they're due, and Bomo said the same thing. So Victor, one of the things that you mentioned is the 15 countries that have ratified the Malabo Convention. And I'd like to come to Dr. Laibuta about this. I know he has some thoughts on what really, if any, will be the effect of the Malabo Convention. Is it a good thing? Is it something that is not necessarily as effective as we think it may be? What can we get from it, if anything, for this region? How can it help data protection?
I've always had a skeptic view about that convention, because one, it's a convention that combines three things: digital transactions, cybersecurity, and data protection. Then secondly, it's a convention that was drafted quite a while ago and doesn't pay attention to the realities of this, especially things to do with emerging technology. Then we also have to remind ourselves that a lot of AU, I think almost all AU statutes really, it's not like the EU where it's compulsory for a state that has ratified to implement that framework. But I think in terms of, I can say in terms of sentimental value, it's good, because we have a document that says as Africans, we need to comply with data protection laws, because you realize that the Banjul Charter on African and People's Rights does not have a provision on the right to privacy. But statutes that came thereafter, the one on persons with disabilities, women, and children, have very specific provisions on the right to privacy. So there's a shift. There was a shift at some point in the African Union, in as much as the Banjul Charter did not have a right to privacy, but now subsequent provisions now provide for a right to privacy. But the signing, the act coming into operation might help, especially in accessing remedies. I think Kapiyo has talked about the issue of remedies. For example, under the African Commission, under the African Court on Human and People's Rights, the fact that this statute is in operation, perhaps if a communication or a complaint is made to those forums, then they would say, as Africa, we have recognized that this statute, the right to privacy, is a right that holds water. But I think we have to wait and see how that pans out. On whether this statute will inform local data protection acts, I don't think so, because there are not two statutes across Africa that are similar. Everybody comes up with something completely different. Apart from the Nigerians one, the Nigerian Act, which they sort of looked at the problems and improved on it, but everybody has different provision. Even the fact that ECOWAS has a statute on personal data protection that was ratified so many years ago, still within ECOWAS, people have there are countries that have data protection laws. There are countries that don't have data protection laws. But as I said, it's a good shift. It shows that within the continent there's some movement, but there's not that uniformity in terms of what we need to have as a law. I think, and Megan mentioned also, will you have group rights as a privacy group rights? This is something that some academics say that no, some academics say yes, but it's something that we need to consider because we have the African Charter on Human and People's Rights. So in a nutshell, good movement forward, but sometimes the movement is a rocking chair. When you look at a rocking chair from far, you think that it's moving, but you're just moving from, so you're just still on the same point. Yeah.
So basically, Mugambi, you're saying, not too bad. And I'm wondering, Grace, do you have any additional thoughts on the Malabo Convention and how it could affect municipal laws in this region?
I like to think of the convention more broadly than just the text of it, and also think about, for example, the processes. People who are here in the I think 2009 or thereabout, there was another process where civil society really fought back against a convention that was just looking at everything digital as just an enabler to national security. And there was a lot of pushback that finally gave rise to the Malabo Convention. And so whenever people talk about the Malabo Convention and maybe why countries have been so slow to adopt it, perhaps that is one of the reasons, which at the same time is a win for civil society because it raised awareness among states that this digital revolution is not just about revenue authorities and national security agencies getting more access to data. There is more to life than that. The digital revolution should also be about people getting a higher quality of life, having more autonomy. It doesn't mean that since people have bought smartphones, that they are at the same time allowing everyone and anyone to also have a look at their personal lives, how they move, their body, what is it called? The body sensors thing, which measures how your body is moving. No, it just means that, like other citizens of the world, they are interested in going back to I think it's the UDHR that pronounces this right of everyone to enjoy the benefits of science and technology. So enjoying the benefits of science and technology should not automatically translate to everybody who's more powerful, for example, states and private sector, getting an inner look into your life and then using that data to control you. That said, I agree that because the convention, like any other negotiated document, has a lot of, what would you call it? Is not perfect. So part of the things that, all the things that Mugambi has pointed, Dr. Laibuta has pointed as not being perfect, I totally agree. Yet I think, and this is perhaps where we depart in our thinking, I think a lot of the African countries have all adopted the GDPR in different languages or in different texts, but we're all basically just adopting the GDPR. It's for a practical reason. People still want to do business. Countries still want to be attractive, and they think the easiest way is to have the basics, and they think the basics is GDPR. But like we are seeing from countries like Nigeria, GDPR is also not the best fit for African countries. Even if you choose GDPR, you still have to adapt it to the situation. So take Kenya, for example. We chose GDPR and tweaked it a bit. But you saw, like in the example that Bridget shared of WorldCoin, there are still problems with that approach because it's not the best approach, like Megan was saying, for collective rights, right? If we're looking at data protection from a collective perspective, perhaps it would have been easier to identify WorldCoin as a problem and solve it even before it became so big, because our law still expects the people who are affected to take themselves to the Data Protection Commissioner and complain in order for the Data Protection Commissioner to take action. That is the most default and direct way to make a complaint. And so because the private world, the private sector does not approach Africa as, oh, there is Kenya, there is Uganda, there is Ghana, Cote d'Ivoire, at least it's AFCON. I know a lot of countries right now. They are coming off the top of my mind. All the countries with red, yellow, and green flags, top of my mind. But anyway, the private sector does not approach Africa in terms of many separate countries. Facebook, if to take an example, is all over Africa. In fact, their operations are ran as, Africa and Middle East, right? So I think there is some value to having the African Union, which is our collective intergovernmental organization, also approach digitization from a collective perspective, the same way that big tech is looking at it. So while it is good that the countries and all the states are doing their own, they're doing their part as required and is very important, there's still a gap in that nobody is doing a collective and looking at the continent collectively and saying, please come slowly, putting the brakes on some of the things that are happening, which is what the Malabo Convention would be a starting point for. So it's not perfect, but it would be a starting point for a collective approach to regulating and even regulating some of these experiments, because some of them are experiments. Yeah, they are not yet tested to be fit for humans like us who just want a better quality of life. Yet they are being tested in our continent. So I think that is one way that the convention would be really useful. And so it's a high time countries outside West Africa, like Kenya, also adopted and ratified the convention so that there can be a space from which there can be collective reaction to some of the things that are happening collectively.
Staying with you, Grace, and I'd also like to hear from Kapiyo about this. You've mentioned to some extent when you were talking about the work that you do on public data, and even now as you were talking about the convention and the push towards digitization, some of the risks to privacy and data protection that we're experiencing in this region. And I'd just like to hear from you what you would say are, some of the greater risks to data protection, to privacy that you've seen in your work coming up for the most part for the whole region, especially when we talk about digitization. We're talking about digital ID, government now using a lot more data to make decisions, provide public services. What are some of the risks that you've come across in your work on public data?
I'd say one of the greatest risks is you put the tech first, and then later on you can put the law or the framework. So there's a lot of tech everywhere. 2 days ago, we were in hospital trying to sort out a case for, a friend of mine. And everyone kept saying, no, but the person who's registered on that NHIF has to come from wherever they are because we need their biometrics, because NHIF is now fully biometric. And the whole time I was like, oh, since when? And everyone else was like, no, that's just how things are done. Of course, with my civil society mind, I wondered, did they ever do a data protection impact assessment? Who stores that data? Where is the copy of those biometrics? Are they even registered as a data processor stroke controller? But you see, at that point, when all you need is for NHIF to what is it called? Authorize something that you need, and it's a doctor who needs that test, you don't think about it. You ask them to take your biometrics. Do you need my toes as well? What do you need? My fingers, my toes? What do you need to sort out my patient? And I think that is how it's happening in a lot of African countries. Tech first, the law and all these other things about civil society, governance, human rights, all those things will come later, which is such a huge risk because the people who implement the tech, half the time, and it's not to say that they're bad people, but half the time, human rights is not their main issue. Their main issue is how can we calibrate those biometrics so that they can be read as fast as possible. Is NHIF for people who have problematic fingerprints, which is the latest technology we can use to better read those fingerprints. So they don't think about, but what are the human rights impacts to collecting a lot of biometrics of even children, you have pictures of children on that database. And so this whole approach of let us first do the technology and then whatever else, human rights can come later, is such a huge risk because it is what is making Africa such a testing ground for all sorts of experiments, including biometrics. And we had that case in Kenya for WorldCoin. And this is the one that, came to the limelight. There are many others going on all over the continent. And let me just stop at this so that I can let others also.
Victor?
Yeah, share others, please.
Okay, thank you, Grace. I think those are very, it's a big problem. Put the technology first and then we deal with the other things later. And of course, with technology comes the risk of data breaches, especially, for example, with digital ID programs where there's a lot of mass biometric data collection. And we are seeing a lot of these programs popping up across the continent. And, lessons need to be learned about cybersecurity risks and, threat of data breaches. We've seen the Aadhaar system in India being hacked and a loss of data happening in Estonia, which is one of the shining examples. Also, information of 50% of the citizens, being captured. Here we are seeing, our e-citizen, everything is moving towards e-citizen, which means all that data is crossing that platform. But what we don't have, the service, I think, was down for a cyber attack a couple of months ago. Yes, it was a DDoS, but, it means that it is not out of the question that the system can be compromised. So I think there is need to start paying attention to the cyber risks that could result from the consolidation and centralization of these databases in the absence of very clear safeguards to secure the systems, and even communication to the public that we are putting in adequate mechanisms to safeguard and secure the data. Second, related to that is, our independent data protection bodies have yet to find their voices. I think there have been many incidences where privacy breaches have happened, but that authority to communicate and to, I won't call it crack the whip, but to restate the importance of national institutions or bodies or organizations that are collecting a lot of personal data to take steps to safeguard or even to, take appropriate measures. I think that voice isn't as loud or as pronounced as I think it could be. The other risk is, surveillance. And, tomorrow we'll be launching another report looking at surveillance. But, a few weeks ago when, somebody was saying all the banks have sent people notices that they're going to be down, they are getting data from KRA, and everybody started getting scared. Nobody wants to be surveilled, and if at all it has to happen, then it has to follow due process. And at the same time, we have exemptions to our national security bodies to access all the data they want. And we also have a strong push to digitize and collect. And so this is creating a lot of apprehension. And I think recently we've seen people starting to do away with, and we were talking about this earlier, starting to use the withdraw instead of doing your M-Pesa transactions because there is fear. And we also saw, I think before the election, people starting to move to services like WhatsApp for their conversation because of fear that our mobile communication, somebody might be listening. And I think the way the current systems are organized, there's not enough clarity and oversight of the bodies that have capacity to conduct surveillance. So it's a problem. I think I'll also talk about, this new technology, whether it is through the large language models and, artificial intelligence or automated decision making. All these digital systems are presenting a new risk, some that we don't even know as yet. And we are not probably studying a lot of it to understand. Many years ago, the landline could only make calls. And then we got our dumb phones. They could only make calls and send messages, and probably you could play Snake. Now, the phone can do much, much more. And I think Samsung just introduced the Galaxy with AI features, and Google has all that with AI features. And, all these are using data from somewhere. And we need to start thinking when government services, for example, start incorporating this, and we were with Grace during the launch of one of the stakeholder meetings for the Maisha number, and they had a facial recognition service where they can tell the age, and we're like, okay, but how? So those are important questions that we need to start thinking about. And I think lastly is to also start thinking of how can systems be, privacy centric or have the data subject at the center. We say it in theory that the data subject is at the center, but if you look at the systems that are being designed to collect data, the data subject is a very small pawn in the bigger picture of things. Whether it is Huduma, Maisha number or election registration, we are just items on a list. So I think we need to think of how do we bring back, the data subject and put them at the center so that then they're actually protected and not doing it the other way around where the data subject is outside and looking in. Thank you.
Thank you for that. And as we continue to talk about the risks and the challenges, I'd like to come to you, Cynthia, especially as someone who sits, in a slightly more private sector leading place. What are some of the risks and challenges that you observed in your work in the private sector? And just to follow up on that also, how do businesses, especially such as the one that you work for as a private sector person, how do we balance and how do you find that balance, if any at all, between a profitable business model and the human rights, the very real human challenges in data protection and privacy?
Well, thank you, Bridget, for those two questions. First, I'd like to shed light on the risks and their real risks. For business, I'll just make reference to what Victor said, that when we are onboarding products in corporates for like financial solutions, for example, you'll find that the business is having a problem and they need to solve this problem. So what is the solution? Yeah, it could be they also want to reach more customers, but that is not the first thing that comes to their mind. The first thing is when you reach more customers, then it means there's more profit. So what tends to happen in the private sector is there's a lot of profits first, tech first. Let's have the solution first. Then the solutions or the human-centric aspect will come in later, probably at implementation. And I think that is why we have these data protection impact assessments to be carried out. And the law has specifically stated that at any point when an entity, either a data controller or a data processor, is onboarding new solutions or they're running projects or changing their systems, then you have to carry a data protection impact assessment. But it didn't just start from the data protection laws and all that. Way before the data protection laws came into force, we've been guided as business by the United Nations Guiding Principles on Human Rights and Business. So what does it mean if we had that at that time? There were human rights impact assessments that used to be carried, but there was a gap in terms of who are you reporting the human rights impact assessments to? There is no regulator. So one of the key risks is the aspect of it really like enhances when you have tech that is not human-centric. It's like it marginalizes people further because not everyone has a solution or rather a device that they can use to assess the products and services. And just borrowing from that, I'd say then the commissioner's office is really doing enough work in terms of ensuring that the business entities cover the risks, because why do we carry out a DPIA? Is to assess the risks that will be presented to the end user. That is the consumer, you and me, right? And then what are these risks? We classify the risks in terms of their level, whether it's a high risk, a low risk, or a medium risk, and give mitigating controls. So what are the mitigating controls? And most of the time, we come back to cybersecurity, what Victor said. What are your solutions to enhance the data security in the systems? So we have to go back and work with the tech community closely when they're coming up with systems, innovating, developing systems. And that is, I think, the biggest gap that I've gotten to see, where innovation happens and it is more of business-centric than human-centric. So, and I think this is just a rallying call to lawyers in the room. Like, we might have to learn a bit of tech for us to fit in the space as well, because that is where we get to advise business what needs to be done at this point. Or we don't have to have situations where they come up as afterthoughts, right? And that is what happens most of the time. And the thing is, the moment you miss a step in the whole development process of a solution, then it means the system has to be redone. Yeah, some cannot just be amended. You wake up and you're like, okay, we need to have a consent procedure. Let's say we are supposed to manage consent. We are processing data. It is sensitive data. And as we change how we process personal data and identify individuals, let's say we are using biometrics, then biometrics fall under this class of sensitive personal data, my facial recognition, right? And the rights in the Data Protection Act clearly say that one has a right to object. So if a customer comes in and you tell them, we need to process your biometrics, they're like, no. What law says you need to have my biometrics. So you need to have a legal basis. But then we have to find that balancing point. Where do we strike the balance between the solutions we onboard and human rights? On to your second question. Maybe you can come again. Just.
The question was, how do we balance then a profitable business model with human rights? Because even as some of the things that you've mentioned about maybe having DPIA or having to gain consent and having the frameworks for this, if you look at even consent, for instance, it means if I don't give my biometrics, I don't get the service to some extent, right?
Precisely.
So do I really have consent? Do I have power over this consent that I'm giving? Is it informed and free consent? And so when you're formulating some of these frameworks, whether they have to do with the end user directly, or if you're talking about, for instance, the DPIAs that you've mentioned, something that's coming to mind for me is there a standardized level for DPIAs? Who comes up with this standard to make sure that they're efficient in how they're done and they're effective as possible? And after this has been done, is there then a metric for the risks that you've identified? You said that you identify whether a risk is high risk, medium risk, low risk. Is there a standardized metric across the board for this to be done from where you're sitting? And if there isn't, how effective can we truly say this stopgap measures are?
Well, so in terms of, I'll start with the metrics. The last part of the question is we go or we are guided by what the regulation says, but the businesses are different, yeah? So there's no one size fits all. It's the business to define. And that is the first stop that the business has to come to an agreement that these are the metrics for carrying out this. But then business needs cannot, supersede statutory requirements. Statutory requirements come first. So it's good that we have our data protection regulations, and it has a standard template for carrying out a data protection impact assessment. And clearly you need to point out the necessity of you processing a certain set of data. Is it proportional to the service or the product? So having stated that, and it is upon the commissioner's office to respond and let you know that there are gaps still in your impact assessment, and you need to do this. Identify the mitigating controls. Do you have cybersecurity solutions? Let's say, for instance, how hardened are your systems in terms of security? And when you were making your presentation, you talked of the data privacy aspect and the data protection aspect, and you said data protection is a subset of the privacy. So the protection aspect is what most of us are still grappling in the industry, because industries, there are no sufficient, actually, I'd say solutions are there, but the financing aspect, the funds to onboard these solutions is a challenge. Let's say it's a startup, like what, I don't want to make specific reference to any entity, yeah? So if you're a startup, then will you be able to afford a certain solution? So it goes to the size of the entity and what their interests are and whether they really are human-centric. Far from that, having worked in the private sector and from experience, I'd say every year entities, corporates, they publish their sustainability reports. And what do you find in a sustainability report? You'll see that they will have to give metrics in terms of compliance to certain aspects of human rights. Do you respect the rule of law? Yeah. Do you respect rights such as data protection rights, privacy rights as listed in the Constitution? Do you respect employee rights? So through those metrics, then we are able to measure and see whether the reports are or the entities are actually compliant with certain frameworks and laws.
Thank you, Cynthia. Coming to you, Megan, I think right now, automation is all the rage. AI, ADMs, all the rage. They say they make our work easier, they make things fair. But from where you stand and from the research that you've done, would you say that we are equipped for adoption of ADMs as we stand, especially when it comes to provision of public services? And if not, why are we not equipped? If so, why are we equipped? And what would we need from a law or framework or a policy to ensure that we are fully equipped to deal with the effects of ADMs and we make sure that people's rights are protected?
All right, so it's important to question the motives and to which governments are automating services. The concept of techno-solutionism, where governments resort to technology solutions as a be-all and end-all solution to social problems. And that is problematic because technology is not infallible. It's not a means of medium that will give you 100% results to the solution, to the problem that you're seeking to resolve. Kenya is a case study, in particular, how digitalization and automation of services have been challenged, reveal that there's a callous attitude within which governments are automating services, and there is an absence of an adequate regulatory framework to govern or to guide how automation of services should be affected by government. And as we've seen, public interest litigation has been the foremost recourse to challenge or sort of seek reparation of some sort from the government, as we've seen with digital ID being challenged twice, and recently the government single pay bill directive again also being challenged within the legal jurisdictions here in Kenya. So poor planning and inadequate communication from the government is characterizing how automation is being done, and that does not bode well with the citizenry, because we've seen there are real harms when automation is conducted, and such harms exacerbate the existing socioeconomic inequalities that are currently existent. So, or rather, just to piggyback on that, in 2022, the Kenyan government, through a gazette notice, classified various infrastructures as critical infrastructure. But we have not seen a critical infrastructure regulation or a guideline of some sort to ensure that the critical infrastructure within the Kenyan jurisdiction is being maintained. And that tells a lot about how we are governing our automation of government services. For a government, especially the one in Kenya that is hell-bent on relying on digitalization, it behooves it to have inclusivity, transparency, and accountability in their automation when they are automating government services. We've seen that recently the government of Kenya has concluded a memorandum of understanding with a cloud provider for a cloud-first strategy. And the question we should be asking the government, and some of the things that the government should also be revealing unto us, is what contingency plans will be in place to mitigate any potential disruptions. What are some of the migration plans for transitioning existing government services? Is the Data Protection Commissioner, for instance, be involved when data governance frameworks are being concluded with this cloud provider? Or are we going to see a repeat of what we saw in the election technology, where OT-Morpho withheld biometric Kenyan data because IEBC had refused, or rather had delayed, to make payments? Also, the government is hell-bent on affordable housing, and there is the platform of Boma Yangu. We already have frameworks in place for data protection. Will the government adhere to the current data protection principles in place? Will the Data Protection Commissioner, for instance, issue a decision against a government agency whereby discrimination has been reported, or where a case of automated decision-making makes a wrong decision? Will the Data Protection Commissioner be included within the Boma Yangu government agency that is implementing that program to ensure that a data protection impact assessment, for instance, has been effected? Will the Boma Yangu platform be affected into corruption, or rather co-opted into corruption, as we saw with IFMIS? So there are a number of considerations and lessons to be learned from existing digitalization efforts by the government, by various governments within the region. And unfortunately, we are seeing repetitions of mistakes. So it's again a wait and see approach for the government in Kenya and the continent at large.
Coming back to you, Dr. Laibuta, some of the issues that Megan has mentioned, I could just condense them to communication issues, transparency issues, accountability issues. So what do we need to have within laws that govern certain digitization efforts or automation efforts to ensure that they don't harm people?
So in Kenya, we've had task forces that have had reports on this digitization. We have had the digital economy report in the last government. We had the AI report from the last government, and it had very clear proposals about the need to have legislation and guidelines on emerging tech in Kenya. So those reports were shelved, but then now we have an opportunity because the cabinet secretary in charge of ICT and digitization, he appointed a task force. And this task force is looking at the revision or the improvement of laws within the Republic, within the ICT sector, digital, where they're looking at cybersecurity laws, broadcasting laws, emerging tech, data protection laws, etc. Because when you carry out a critical analysis of Kenyan laws, especially in terms of data governance, there are a lot of gaps. And these are the gaps that allow for us to have the technology first and the law later. So hopefully, this reform process that is being spearheaded by the Ministry of ICT will address some of the challenges that are being raised here. The challenges of identifying harms, the challenges of having tech first, the challenges of analyzing that tech, because what Cynthia was talking about carrying out data protection impact assessment, that is within the Data Protection Act, but there needs to be a deeper analysis. For example, the AUAI Act proposes for analysis of tech, analysis of AI solution to look at AI impact assessment, which is broader than what we have under the Kenyan data protection law. Because even if you are saying that we look at this tech and we identify harms, what tool are you using? And is that tool provided within law? So that you can, somebody can say, somebody who's been denied a service can actually say, like what Megan was talking about, like, Bomayang, if you're denied, for example, access to this affordable housing, what tool, apart from just saying that my right under this article of the Constitution has been violated, you need a lot to say what tool could, for example, the courts, the regulators, and the implementers use to identify these harms and to help mitigate those harms. And I'm saying this process that is ongoing now, revision of the laws, perhaps will sort out that. But even without that happening, I think it's also an issue of, I don't know who said it, that historically people have, for example, like when I work with private sector clients, I think it's Cynthia who says, they're looking at profits. These issues you're talking about, human rights, it's like somebody has put in money. They have put in, let's say, 1 million shillings into this business. Within X number of time, they want 1 million plus X plus Y. So this issue you're talking about, Data Protection Act, CBK regulations, and you've seen it with digital lenders, these rogue digital lenders. Some don't even register with the CBK, with the Central Bank of Kenya, because they're thinking, we have this 1 million we've invested, how do we get? So and you're trying, and in Kenya, you see what happens is like, it's like when you're overlapping. I think for the Kenyans in the house, once the first person overlaps, the rest of us overlap. But before anybody because you usually check and see, is there anybody overlapping? Then when you see somebody has overlapped, yes. Then when there's a policeman there, we all fall back into line. But another thing that I like about what the data commissioner is doing, our law may be faulty. It does not provide what we call textbook independence of the data protection commissioner. But we've seen communication from the data commissioner that is punitive. Administrative notices saying this and that establishment has gone against the provisions of the Data Protection Act. But I think there was a question, I don't know whether it's Megan or Kapiyo who asked, what about now public bodies? Last year, 2022 and 2023, the information regulator of South Africa made two decisions that I thought were amazing. One, it wrote a notice to the national SPS, the police service of South Africa, and told them how you're processing data of suspects is wrong and in violation of the provisions of the Protection of Personal Information Act. Another decision that the information regulator did was in relation to the Ministry of Justice. So the information regulator is under the Ministry of Justice. The information regulator investigated how the Ministry of Justice, I think it was some system, some software, and they told them to carry out a DPI. The Ministry of Justice like, you're under us, so what are you telling us? Then they find the Ministry of Justice some millions of rand. So there's that question about regulators taking action, because the information regulator was saying, we gave these people an opportunity to comply with the provisions of POPIA. And since they have not complied, then we need to take this action. So the question is now the intersection between the data commissioner, for example, and government entities. For example, the commissioner herself should say, like, for example, in the it's called Moja Express, the Umoja Express, the expressway that the commission gave guidance, and we saw some changes in how the data was being processed. But now there are questions being raised about e-citizen. I think it's also saying, is also being open and say, yes, we're in collaboration with these entities, because I think that's what worrying people, where that visibility. And then if there is a problem, then action can be taken the way the information regulator is there. But I think for us, we have seen, I mean, especially for me and in my research, we've seen the data commissioner being candid, being part of those processes. But I think what people are waiting to see is action. Because also when you look at our Section 8 of the Data Protection Act, it talks about collaboration with national security organs. And anything and everything can be termed as national security. You can say the expressway is national security. You can say citizen. You can say Boma Yangu is national security. But also, even with that, without all that, there's this group of Kenyans who are carrying out public interest litigation. We've seen Katiba Institute go to court about the WorldCoin issue. Even after the data commissioner issued advisory on it, they still said, no, we are not satisfied. And I think that's how we need to grow the space. We've seen action taken against, I think Access Now, you're involved in the one against, what do you call it? It's not Huduma number. Yeah, Maisha number. So there are a lot of different initiatives that can be taken together to deal with those issues. For example, in the Nyumba Yangu, we are seeing that there is a problem here. And we feel that perhaps the regulator is not responsive, or the regulator is not giving us the response that we so desired. I mean, you can go to court and seek direction from the court. Like, for example, the data commissioner got a lot of flack with the WorldCoin issue. Then later, the commission issued a very comprehensive statement of what action needs to be taken. But I think WorldCoin, before the parliamentary report, WorldCoin was like, I mean, what are you going to do to us? So I think it's also a combination, the need for regulators to work in concert. For example, in the WorldCoin issue, we don't just let the data commission act alone. If there are other regulators involved, for example, Communication Authority, Central Bank, and any other authority, for example, the NC4 on cybersecurity, we need to have measures where they can work on concert, because some of these things you just allow one regulator, and that is a gap in our law. And one of my proposals is that we need a framework where regulators can speak to each other and can deal with these issues in concert, so that we don't allow now one CAK has made their decision there, this other one has made their decision there. But if there is a way that there can be collaboration and come up with uniform guidance notes or uniform decisions, like, for example, in the WorldCoin thing, then that way, because people think it's just the data commissioner that was at fault. No, there are many other regulators who dropped the ball. And that is the gap in our law that I think ideally we need to address, even with the digitization of government processes. For example, where's the Kenya National Commission on Human Rights in all this? That's a state where I think, I don't know, it's Megan who also talked about the issues of inclusivity. Where is NGEK? Where is NGEK in this conversation? It's not just a data commissioner issue. It's all these other people working in concert to ensure that what we are doing really makes sense according to the constitutional principles.
Yep, that's a really good point, Dr. Laibuta. And I'd like to come to Victor in this last section of this panel. And Victor, being that KICTANet works a lot with communities, what kind of tactics would you say have been most effective in getting these conversations, the communities that you work with, especially high-risk communities, to ensure that they're included in some of these debates and influencing policy?
Thank you. I think there are a number of things that have worked over the years. I think basically community outreach is very important, just like Access Now is doing today to reach out to the community. I think having these conversations are very important to highlight the concerns that exist, but also provide opportunities to share best practice across from different perspectives. And, you know, taking the conversations to the different communities where they are in their spaces, and in languages that they can understand. Sometimes, you know, we are here all lawyers on this panel, and so occupational hazard that you know, we speak legalese most of the time, and so you should be able to translate what privacy means to the average. I mean, the Kenyan man on the street or Kenyan woman on the street in Sheng. What does it mean, and what are these rights? What is a data control and a processor in Sheng, so that then people start realizing that, okay, I have something there and it actually means something. So that when there are scary, such as the ones downstairs, request for your ID, you can ask a question and say, but unapeleka wapi hii number and all these things. And when the government asks for information, you can ask questions. When privacy applications on your phone are asking for permissions, people know what to do, because I think many people don't know what to do when we are presented with these problems. We don't know where to go and where we can complain. So that outreach and awareness is very, very important, even for those who think they know, because there's always something new, and we are living in a very dynamic world. So I think that's important. Capacity building, of course, and you know, literary digital literacy skills. We've conducted, for example, digital security trainings and, you know, privacy boot camps and things like that with different groups, and believe that it's important to empower others with knowledge to actually empower others, such as, you know, training of trainer programs, which are very important. You know, we also try to use, you know, Kenya is a very oral society, and theater and drama, and have also been very useful in trying to communicate some of these messages, going to radio to actually find people where they are and join them in their conversations. I think those have been important spaces. But I think also it's important for our regulators and even companies and data process to go beyond putting in privacy notices on websites and actually just tell people. For example, if you're a bank, many years ago, our transactions with the bank, we imagine that banks are only keeping ledger, money in, money out. Now, if you go to any bank, you find they're asking for more information. And then they are, you know, nobody tells you anything. It's just sign here. Where end ujaze a form where we've marked X, bring it back with a deposit. What they do with that information, they're not saying. So data controllers and processors have an obligation to also reach out to the communities who they serve, beyond just taking and waiting for the regulator for compliance. They need to increase those budgets, the 1 million that Dr. is talking about, to also include public awareness about what their service is actually doing, how they're using their the data that people have given them. Because it's not enough to say all the data you provide shall be used to improve the services. No, you need to tell us what you're improving and give us an opportunity to say, we don't think that's a good idea for how we want our data to be used. So I think we need to empower people to be able to ask questions, and not just any question, but also the right questions of these providers. Thank you.
Grace, coming back to you, I think beyond even communities, there's policy that are policymakers and judicial officers and other stakeholders, private companies that are engaging with these issues for the first time. Because as we digitize, that's when we realize that certain things are happening that we never necessarily learned about in school. So how do we have these conversations in a way that best conveys the fears, the challenges, the risks, to ensure that they are actually, building frameworks around the work that they're doing in the most effective way? How do we distill further from, as Victor has said, there are lawyers all over this panel. So how do we distill the information? How do we make information a bit less technical for people who are engaging with these conversations and these issues for the first time in the best way possible?
We had exactly this kind of conversation during those Maisha number conversations. And I saw Victor here a while back, and he'll be back, and you can also ask him about it at the break. One of the things we realized is that it's actually just about breaking it down. People, if you come from, it's called helicopter, when you're coming in to look at the problem from, you think that people don't know, but when you actually talk to people, everybody really cares about their privacy. If you listen to Radio Jambo, people are fighting about a spouse or a significant other having looked at their phone and seen their private message. So it's about breaking it down. But more importantly, something else we found is that actually there's a lot of work that has been done, because these are not absolutely new problems. A while back, I think in 2004 or 3 is when the first Kenya ICT policy was being made. You'll see conversations about people asking for government officers, public officers, back then they didn't used to be called state officers, to use official email addresses when addressing the public, so that people can know that this is official. And you see, this is a problem that is coming up right now in these conversations about e-citizen and cybersecurity, where people ask, but this was hacked because you used your personal email address and you were the weak link in that. So you can see that there's a lot of work that has already been done. If you look at the work that civil society has done on these issues, and there are so many organizations represented here, it's a lot. So it's just maybe about curating, updating the language, maybe now to say we are now talking about. Back then it used to be called e-government, now it's being called e-citizen. These are things that can be done. On the question that Dr. Laibuta has really tackled on these public agencies and updating their data protection and their data governance. A while back, the ICT authority, in fact, that's why the ICT authority was formed, to coordinate government use of ICT services. And it's a whole parastatal funded by taxpayers. This week, we've now really understood. We've understood this concept of taxpayer-funded agencies. So this taxpayer-funded agency, one of the issues is supposed to, or one of its mandates is coordinating government ICT consumption and all that. And at one point, the issue was using open, it's called open source. Yes, open source solutions. I think right now, the issue of the day, the topical issue would be, how can all these public agencies do better as far as privacy and data protection is concerned? And it's something that can be, achieved because they already have a coordinating space, especially from for national government. And I'm sure it's something that can also be replicated in the counties. So I would tell any policymaker who is facing these issues for the first time that they don't need to reinvent the wheel. There's already a lot that exists. There's already a lot of resources in the number of civil society, academics, think tanks, and others who have been engaging in this space. And even where they don't have exactly what you need, trust me, they are willing and able to help you out. So there's that willingness. A lot of us in research and advocacy, apart from making noise, we also want to see better. We celebrate when public agencies do better, and so we would look forward to even advising them as to how they can do better in whatever their mandate is.
And Dr. Laibuta, same question to you really. As an academic, as a consultant, what kind of approach have you taken, especially just, to communicate less technically on some of the issues that we face? Because I think it's very easy, especially for someone with your profile, to fall to the technical side of explaining things. So how do you distill it a little bit further, especially to people who are, encountering these issues for the first time?
At the Kenya School of Law, I teach legal writing, where I tell people they need to be speaking simple English and writing simple English when they're out here. Then I'm in a boardroom, and I find that the advice I give in the classroom sometimes become a challenge to implement in the boardroom. But I think different audiences appreciate these things differently. For example, when I deal with private sector, it's important to tell private sector, what is the business case for doing all this? Because people have put in their money. To be honest, even you, here as a human rights lawyer, when you invest in shares, for example, you want some returns, whether you're a human rights lawyer or not. So it's quite simple. For example, for private sector, I've learned that, especially those ones that are profit-based, what is the business case for compliance? And the business case for compliance is after carrying out an assessment. For example, what will be the harms to the data subjects? What will be the harms to the business for non-compliance? And one question that we asked people when we are taking them through the compliance journey is that, what is your risk appetite? Then you'll find people, our risk appetite is big. Then you ask them, okay, can you soak in the risk? Do you have the risk capacity? Then when they do the calculation, like, oh, really, we have a high risk appetite, but we cannot soak in. We don't have the capacity to soak in this risk. So that is the language that a business entity will understand. And also risks like litigation risk, for example, reputational risk. You have to indicate that they will lose money if they don't do this. When it go there and talk about article this and that of the Constitution, does it bring money? Because that's the question, does it bring money? Then when you're having a conversation with government, it's a bit different, because government, you see, how do we execute our services while we are complying with the law? Because it's simple, like we have a government comes in, they have a manifesto, they have their plans, they have their Vision 2030, Vision 2050, Blue Strategy, they have a data strategy, etc. So the question is, how do we implement our strategy while we are complying with the law? And also for government, another trick is that you also have to ask yourself, who is funding this? Because also the people who are funding the process, because a lot of this tech doesn't come I think very little tech in what conversation we are having is locally built tech. It's tech that is being imported, and that tech is being brought by a development, I think, partner, for example. I think we've had, in the last year, we've been told our country is run by the Brentwood, the Brentwood corporations. So whatever they say, if they are funding Expressway, if they are funding Maisha Namba, if they are funding Nyumba Yangu, what do you do? What is your wiggle room? It's very few, because you don't have money. So for the government is to look at, even when you have projects that are funded by, and you'll have different partners forcing, for example, if it is American businesses, they'll want to say, we want to comply with American law. If it is European companies, they say, you must follow GDPR. If it's Chinese law, they want the personal information legislation of the Chinese. So it's also now, how do you strike a balance? So that puts government at a very tricky situation. One, a government that doesn't have money, a government that wants, they made promises, a government that wants, so it's usually, how do you balance all those? And you see, it's a juggling process. Because it's easy for me as a constitutional lawyer to cast aspersions, but when you go in practically and look at how do we do this, and you realize that who are the entity. So what I'm saying is that, especially for government, you need to map out who are involved in all this. And especially for government, where is the tech coming from? Who is bringing in this tech? And who is funding this tech? And why are they funding it? Then somebody talked about cloud service provision. I don't know whether it was Kapiyo or Megan. We are using a cloud service provider in Los Angeles, LA or San Francisco. What is our protection? And for government, it's usually to tell them that you can execute your services while complying with the Constitution. And also indicating that there's a lot of, there's been debate about the judiciary, etc. The judiciary is very clear. You are violating this provision of the Constitution. So also that usually becomes a threat. And I think that's why for Maisha Namba, there's been a lot of conversation with civil society and even people getting upset that some civil society are still going to court even after this engagement. But that's how the process is. Then for the data subject, I think, and Kapiyo has mentioned, how do you reduce it to how do you explain to a 2-year-old or a 4-year-old that data is important? How do you explain privacy, that privacy is important to them? Because for the Mwananchi, I think I don't know whether you saw that clip in Huduma Namba. There was like a drunk guy that was asked about WorldCoin. And he says, as so long as they'll give us that money, we are registering. You continue speaking what you're speaking. Me, there's money. And for him, this was to come with booze and some jabber of sorts. So there's a direct benefit. So you see, it's also that on the ground, people are like, it's simple, like people are threatened during Huduma Namba. And even the pastors, the pastors speak, and a lot of Kenyans believe in their pastors or the imam. So if the imam on Friday or the pastor says, you need to register, they will register. But it also comes from a point of ignorance. And nobody, as Kapiyo said, nobody has broken down. If you go to them, how do you tell people that data is important, that privacy is important? But this same person will be given some job, let's say in industry area, they'll be asked to do those fingerprints, biometric. They'll be like, hey, I need to eat. Because a lot of people say that people don't care about privacy. People care about privacy so long as it revolves around their personal interest. For example, if there's no way, if I was asked my ID, there's no way say I'm not coming to Baraza Lab. I've made a commitment to come to Baraza. So I say, okay, I leave my ID. But there are places that I'll say, no, I'm not leaving, and I disappear. And I think that's a gap. And I think people like KICTANet are doing this. I think ODPC is doing this with some of these small books, small notices. I think also if you go to access your website, there's where you put it in a very simple language. And I think that is what is required. What Kapiyo was talking about, what Bomu is talking about. This has to be concerted effort to break this to sector specific, because even how you'll address the financial sector is not how you'll address the health sector. And this assumes that even people addressing them and simplifying this understand what they're doing, because there's a big skills gap in people who really understand what does it mean, for example, to pay attention or to put into operation Article 31 of our Constitution.
I'll just leave that one. I fully agree with some of the things that you've said, and especially when you're looking at service provision. And if you ask somebody who has a need for something where they need to give their biometrics, not to give their biometrics without questioning it, what are you talking about? They need this thing, they need to access it. But, one thing that we've encountered again and again in this region is that the problems replicate themselves. The risks replicate themselves, the challenges replicate themselves. And so coming to you, Cynthia, what would you say, if any, the cross-border and kind of cross-country opportunities for us to collaborate in order to come up with solutions that we can apply nationally, regionally, and globally?
Well, so thank you for that question, Bridget. And I'll say, in terms of mutual assistance, where we have shared responsibility, then I'll start from making reference to the AU Malabo Convention. And the reason why I'm making reference to it is when you look at our Constitution of Kenya, Article 25 on international obligations, yeah? When you ratify a certain convention, then you're bound by it, right? So if we can rally the African countries to ratify the AU Malabo Convention, then it means we will have some heightened sense of responsibility as entities, as local, in our local or within our regional economic blocks to enforce certain provisions of the Data Protection Act. For instance, we have provisions where we are required, let's say as a data processor or controller, to make sure that we have our data within the Kenyan jurisdiction. That is the principle on data localization. But in some instances, because you cannot have the solution locally, you have to outsource it from a different jurisdiction. And when you look at what EU is doing, when they've taken the approach of the European Economic Zone, or rather community, then where the different states have ratified that law, then they can easily share data cross-border without having any regulatory implications, considering the level of adequacy of the laws. So for Africa, we have to maybe pick some lessons from such jurisdictions and see the bigger picture. We don't need to be short-sighted in terms of, we really need to stick to our local laws. So if the ECOWAS, like Data Protection Act, came into force way back, then it sent something to the people in that region, yeah? Further, we have issues of cyber attacks, and they don't happen like when we see them. There are things that happen and we come to learn of them way later, like the attack that happened some time back on our telcos and financial institution. And the entity that was claiming responsibility, or states, as was seen on social media, I don't know whether it's true or false, it was Sudan. They said, we will hack your systems, right? But then what responsibilities does a country have in terms of mutual assistance and not infringing another country's rights to disrupt service provision or access? So we have to look at it from a different perspective in terms of what happens when there's a cyber attack in our system. Can we call for country A or B to assist with investigations in terms of forensic analysis and all that? But then if there is no law that really binds these entities to provide mutual assistance, then that cannot happen, right? And I believe that's all for me. Yeah, thank you.
Megan, are there any opportunities for cross-border solidarity that you have identified that we could use?
So there are a number of cross-border opportunities for solidarity, mostly through advocacy campaigns, through drawing red lines to prohibit certain activities and products that are fundamentally incompatible with the realization of human rights. For instance, we have the Global Encryption Day, which is celebrated every 21st of October every year, and a number of institutions, including KICTANet and Access Now, are part of that global campaign. Currently, AI is a very hot topic within the region and the globe. So amplifying, for the continent, we need to start amplifying the labor conditions for our data labelers and data annotators that are from this region, and supporting their unionization efforts. As we've seen, a number of gig economic workers have been able to unionize here in Kenya, Nigeria, and South Africa. Organizations such as Mozilla have been very pivotal to enable solidarity and support within the region, where we've seen through the Common Voice project, whereby they're able to collect public data to build common data sets for AI technologies, and also supporting grantees through, able to support research efforts through granting research grantees to researchers who are investigating or conducting research on the impact of AI within the community. So advocacy and joining public campaign efforts. Yeah.
And as we come to an end of this discussion, I'd like to start with Victor all the way this way and ask our panelists for the day. If you could change one thing in your sector with regard to data protection and privacy, what would it be?
I think if we were to rub the proverbial lamp and make a wish is for our regulator to be more proactive. I think they have relied a lot on the complaints coming in. I think it's important for them on their own motion to just say, we have investigated, because they have an investigatory mandate. We have investigated and we have found and we have recommended, oh, these are the steps we are taking. So that then people can know that they are not just sitting in their nice shiny office waiting for guys to go and report, but they're going out and doing the job that needs to be done. Because we can't continue with that approach that let's wait for WorldCoin to happen and then come out. We wait for Maisha number to come out, then we say, you didn't do this. I wait for Safaricom to ask for people, then, you're doing this. That's important, but they need to have in place the structures, build the internal capacity so that they're able to be more robust and agile and responsive to the emerging challenges that we are seeing today. I think that would be my wish.
In one word, data economic justice. We need to be cognizant of the economic, social, and cultural implications in data value chains. And in that regard, therefore, for us to be able to have a just digital future, we need to have a radical social political shift whereby economic equality and equity is primal in our digital transformation, our policies that we have.
Well, so for me, my parting shot will be that everyone deserves the right to privacy, despite their age, gender, all those. And for the private sector, I'd say that there's no privacy without data security. And we really need to embrace cybersecurity solutions, whether it is firewalls, whichever they are, and as well as cyber insurance, because this is an industry that is highly regulated. And another aspect of it is nobody ever wants to take liability for a breach. Everyone is risk averse. So the solution will be, let's invest in cyber insurance and solutions.
Because I'm working in public data at the moment, the one thing I would ask the Victor's Genie is for government to set the standard such that when public agencies, be they national government, county government, even when people are coming in through the ports, that everything is done with the highest possible standard of privacy and data protection, such that even the regulator, who is sort of part of government, even though they're independent, even the regulator would be able to tell everybody else, look at the standard that is being set by public agencies. You all need to rise to that standard. So if you vote for me, I will.
I think when you speak last after such awesome contributions, it becomes difficult to know what to say. But I'll say this, I think one of the gaps that we have is the data governance professional. And in terms of skills, knowledge, and experience. And for us, what we've done, and Bomu forgot to say, she's our secretary at the Data Privacy and Governance Society. And Cynthia is one of our active members. And one of the things we realized is that as data governance professionals, it's really not possible to know everything. You might have those academic qualifications or those certifications, but we also need to learn from each other. Like for us as the Data Privacy and Governance Society, we have representation from civil society, from public sector, from private sector, from academia. We have young professionals who are 5 years and below since graduation. Currently, we have one university chapter, the Data Privacy and Governance Association of Nairobi University. We hope to spread that. And what we've realized is that that kind of camaraderie and sharing knowledge, sharing skills, and mentorship, then it has helped a lot of us, whether you have many years experience, whether you have a few years experience, to know how to troubleshoot some of these things we are discussing. Like, for example, we have very robust forums where people raise issues. Somebody can raise that issue, like what you're saying. Somebody can say, what do you think of the Malabo Convention that now it's come into operation? And you'll find that there's somebody from public sector will have a different opinion. The private sector person will have a different opinion. The academic, like myself, with our very skeptic approach. And I think once we continue with this kind and bring together all of us as data governance professionals within forums and with spaces where we can build and mentor each other and build these skills, then I think we will now have a critical mass of people who can advise these sectors that we are talking about, or at the very least give objective opinions or views, whether they are taken up or not.
I would like to now come to our audience, both in person and online, and we are happy to take questions if there are any questions. Hands, please, if you have questions.
All right. My question is on access to information, where it says that everyone has the right to access information either held by government or by another individual, and especially where such information is needed to either protect or enforce a fundamental right of freedom. So then my question is, especially where such information is really personal, so how do we strike a balance between access to information and data protection? What does the law say, or what are the steps that such a person who wants to access such information must take, so that we balance between these two seemingly conflicting rights, the right to privacy and the right to access information, and the need to ensure that even this person who accesses this information does not hold it in perpetuity, but only uses it for the intended purposes. So how do we strike that balance? Thank you.
My name is Angela Minayo. I work at Article 19 Eastern Africa as the Digital Rights and Policy Officer. My question is around processing of sexual orientation and gender identity data. I would want to get the insights from the panelists on the trends in the region. I know that gender identity data is recognized in the SADC model law on privacy and data protection, but what are the countries handling? How are countries handling the fact that they're going to be processing data that has sensitive information around sexual orientation and gender identity, knowing that in the continent, there is a lot of homosexual or anti-homosexuality laws, and that means that this subset or group of people are at a heightened risk when this data is breached. Thank you.
Okay, so we answer those first two and then take a following question.
Okay, so the first question. So the right to access information is not an absolute right. The right to privacy is not an absolute right. Both of them are rights that can be limited. So when you carry out comparative research, you realize that the answer is usually, it depends. And I know that's a very lawyer answer, but you have to balance between why do you want that access and why do you want to protect privacy? So there are several considerations that are usually made. One, what is the reason? For example, if you look at the Rwandan Access to Information Act, it says, what is the reason? Even they can, why do you want to access, okay? some people argue that access, you don't need a reason. I just want access and that's it. So what is the reason that you need that access? Is it to protect a fundamental rights of freedom? Then that will rank higher. Are you a researcher? Are you a journalist? For example, it's for journalistic reason, that perhaps will rank higher. Or if you want the data just for the fun of it, that you can access the data, then there has to be that balance. Then secondly, you need to look at what are the potential risks of sharing that data with you, because there's also data that we can't avoid those two words that we don't like a lot, national security. How will this affect? Like, I mean, you and I, we go to DOD today, we say, you know what? The Constitution allows us access to information. We want to know how many people you've deployed here. So you get the flow. So it's also what are the potential risks of that access to information? Is there a risk-benefit analysis? Then something else that is usually considered, will there be a risk to others? Because, for example, some people seek this information for nefarious reasons. I can give an example, and this example is common, where your significant other disappears for whatever reason. Maybe they don't want any information, they don't want to live with me, or they don't want to live with you. Then what do? Then I go to Safaricom and I say, I know somebody there, give me information about Bridget. She went away and I want to know. So then they don't know I'm a risk to her. So the question is, my access to that information, is it a risk to another human being? Is it a risk also to the fundamental rights and freedoms of other individuals? So you have to carry out what is called a proportionality test. And that is why, ideally, I know our regulations on access to information are not very clear, but you need to carry out a proportionality test. And that proportionality test will help you identify this. Like the access you're seeking, is it sanctioned by law? What are the potential risks? What are the potential harms? What are the benefits? Then you may be granted that access. So there's no straight, because at times, for example, if it's for a public issue, because let's say there's been pilferage of money in a county, they can start claiming the right to privacy and deny you access if you're a journalist, or that information ought to be public, how public money is used. But now if you, let's say, for example, you go to the Kenya School of Law, this Laibuta has been teaching here, I want all information, I want his personnel file. Why do you want that personnel file? So those are the different situations, but none of those risks ranks higher than the other. So I say it depends.
Yeah, I think with the aspect of SOGI data, I think it's still I won't say an issue, but different approaches, because you find that many countries you collect data on sex, but so not many are collecting about orientation or identity, right? So you can say from a basic level that because it's not being collected mainstream or required to be collected, for example, for registration, then it's a good thing. But on the other hand, it's also being collected, whether for health purposes or for profiling. And I think that's why we have the bigger problem. In the health sector, you find that SOGI data is being treated as part of health data and medical records. So it's protected as such, because those, even here in Kenyatta, you find that, for example, men who are having sex with men go for treatment and they're getting the HIV medication, and that information is not being revealed to the public. But at the same time, police officers who are targeting or, policing the streets will arrest sex workers, including male sex workers, based on profile and where they are. And that information, then we find that is still being collected. So I haven't seen in terms of approaches by different countries from the legal perspectives in terms of the privacy, because many, even when they're defining sensitive data, is still sexual orientation data is not listed in the categories of sensitive data. But increasingly, we are having social conversations where there is a strong feeling by population that that is some of the information that need to be be protected as sensitive data, because its disclosure can also lead to further violation, but is also a new class of personal data that is a subset of the sex data. So I haven't seen many examples, but I think it's something that is still open for conversation and more advocacy, especially by human rights groups.
Thank you. Barring are there any other questions?
Yeah, that was the
There's a
final
question
one.
there. Okay.
The final two.
There's one other one in the back. Okay.
Hi, Ms. Lee. I am a journalist speaking to a panel of lawyers. How public awareness have in cases of, because most times we hear organizations versus the authority or organization versus organization. So have we seen individuals suing or agitating for the protection of their data rights, or wondering how their rights were infringed? If there's any successful case study in the country of individuals agitating for these rights, then
Good afternoon. My name is Jamal. I work with Haki na Sheria Initiative. So my question to the panelists would be, do you think that investment in growing local skills and infrastructure in order to reduce over-reliance or in order to reduce over-reliance on foreign corporations will be a mitigator to the risks that come with, foreign corporations heavily being invested in, let's say Kenyan digital public infrastructure? Yeah.
Okay, on the first question on individuals advocacy, yes, last year, 2023, there were quite a number of cases that the Data Protection Commission shared a decision with. One involved a child with some school, uko in Uthiru. Another one involved this issue of pictures being taken at the club. And you remember after that, there was a whole, every club on social media put out their policy. And they had something at the entrance warning you that you're now entering a place where photographs may be taken. So there are those ones. Of course, we are just beginning to see the beginning of these things. There's also been an interesting case where they took a criminal route using the Computer Misuse and Cybercrimes Act, ASIAD, what are they called nowadays? Not influencer, but content creator. The content creator, she's a media personality. Her personal data was violated, her personal phone number shared, and she became a complainant in a criminal case that is ongoing in Nakuru. So yes, we are beginning to see these cases even by individuals. I think one of the predictions from a lot of data protection practitioners in 2024 is that we are likely to see more because the awareness keeps growing. And so I think people are now advising anyone who processes data about children to be super careful, anyone who processes data about vulnerable groups to be to review how they process that data, why they process it, and all that, because the awareness has been rising. Of course, very few cases, but the awareness has been rising.
I think a very quick answer to the second question is yes, it's important to invest in local talent, and a number of organizations are doing so. Like I had mentioned, Mozilla is running a number of, I don't work for Mozilla, is running a number of projects to support talent in AI and digital infrastructure at large. So a quick answer to your question will be yes. Any panelist who has an additional thoughts on the second?
On developing local talents, on coming up with innovations and IT solutions, I believe building capacity in local talent is really significant because they are the people who understand the situation in the ground, on the ground, I mean. So looking at it from a local person's perspective and coming up with a solution gives more leverage to the local service provider who wants to consume such services, because this person understands the prevailing socioeconomic situations, unlike maybe a foreign solution that has been imported, because these solutions come with different levels and standards. But then what are the standards locally in Kenya in terms of, we have this solution, we need to solve this problem. And we look at it also from the point of accessibility. How is the infrastructure locally? Are people able to access this product? Because you might import a product and it only works on an iOS device or Android, yeah? But then we have people with Katululu. How can they access that product? Then you have to look at it from maybe using a USSD solution, yeah? So ingrown talent will solve most of our challenges, including data localization. Yeah.
Indeed, I agree that a lot of the time we import solutions that don't necessarily work for us. And that has been a huge problem for us in digitization in this country and in this region. I see there's one more question over there and another one in the back. If you'd like, please address a question to a particular panelist if you prefer.
Thank you. My name is Linda from the KICTAnet Network, a legal fellow. My question is, what are some of the practical recommendations that you can take to the government in terms of mitigating some of these risks that come with digitization of government services, that comes with also, as we saw, with the cyber threats, with the digital IDs, with the Maisha number? What can you tell the government to do practically to mitigate these challenges? Thank you.
Yeah, thank you all panelists for the insightful comments and input. Dr. Laibuta, to your comment on mapping, I thought it was very insightful, but I want to ask, how do we ensure that engaging with the so-called development partners, and once you've done that mapping, that the engagement is just not tokenistic, so to speak? And to Grace, you spoke about public data governance, and you cited a case where NHIF now requires you to provide your biometrics, for example, to access health services. How do we ensure that such instances where DPIAs are not conducted, as we see with Maisha number and the case you mentioned with the NHIF, how do we ensure that there are remedies to cure such instances where there are deliberate breaches, but people go ahead with them because they have no other option, as we saw in the case of Huduma number, where it was essential to access public services? Thank you.
Thank you for those questions. First of all, to the recommendations question, I'm going to very shamelessly plug our paper, which has a couple of recommendations. You can read that. There are a couple of recommendations on transparency, accountability, legislation, ratification of certain laws. But I'm sure our panelists here might have a few more recommendations that they'd like to mention, so please feel free. And I will hand over then to Laibuta and Grace for the questions that were addressed to them. But if anyone has any recommendations that they would like to mention, please feel free.
This one on engaging development. Let me give an example of Pegasus. So Pegasus, when it became the tool of use for a lot of governments around the world, of course, there was work that was done to challenge Pegasus directly and tell them what you're doing is wrong. And how did people know Pegasus? Because it was Pegasus, because some research was carried out. And this was in collaboration. Civil society collaborated with researchers, academic researchers, and they got to understand what was happening. Of course, the governments that were using Pegasus and Pegasus, they ignored. But also that provided an opportunity of a whole lot of data that could be used to challenge Pegasus in courts of law. Pegasus, there was a case filed in the Constitutional Court in Israel and another one in the US. And then also there were complaints made in the US Congress, there were complaints made in the EU Parliament. So it's once you map, then you know what is your strategy and how do you engage. In the ideal situation, you'll engage these people developing these products and they'll say, okay, we've listened to you, and they'll implement what you're saying. In the event that they don't listen to you, then this gives you an opportunity to know, for example, if this is, if Kenya is using Pegasus, where do we file a complaint? Where do we file a constitutional petition? Do we file it in Kenya? Do we file it in Israel, where the company that owns Pegasus is? Or do we go to the US, where they might have a subsidiary? You get what I'm saying? So it helps you create that avenue. Also, unfortunately, some of these companies or corporations that bring tech to Africa, I think somebody say they take Africa, I think Bomu say they take Africa as a country. So when they take Africa as a country and say, we'll do what we're doing in Burkina Faso, we'll do it in Sudan, we'll do it in Kenya, we'll do it in South Africa. Okay? But another strategy is usually once you identify these companies, because they have extraterritorial rules that apply to them. For example, I'm sure you've seen companies that are being fined because of anti-bribery, bribing in Africa, for example. There are laws about business and human rights in the US, in the EU, in the UK, so that once you engage with these companies and you realize they're not listening to you, then you can have, for example, you remember the tea issue, the Kericho tea issues? A matter was filed in Scotland. After many years, people engaged these companies and they said, Utadu. Okay, then people said, we'll file suit in Scotland. And the Scottish court said, yes, we'll accept these petitions because this is a violation of our law. So long as you're a company that is duly registered in the UK, you have some standards you need to follow. But in Kenya, you are not following those standards. So when you do that mapping, then you're able to know, in the event that these institutions, you engage with them and they ignore you, what strategy can you adopt?
Okay, on the question on DPAs and what people can do, I think the first thing is raising awareness. Successful public interest litigation, for example, has succeeded because there was a lot of also public interest. So we cannot overstate the role of the media in helping raise awareness and let the public know what the issue is with some of these or what are the gaps with some of the technologies that are being deployed, for example, now that biometric. And other than that, there are so many other approaches. I know, for example, when laws are being made, like the Data Protection Act, civil society really pushed for something called access codes. And this just basically means that all these public agencies are supposed to have a code or like rules on how they share data. Unfortunately, none has published. Yeah, not that I'm aware of. None has published their access codes, yet we know that they're sharing data. We know, for example, for sure that you can also access NHIF through eCitizen, meaning that even for us, even if you didn't know tech, that tells you that there's data sharing between NHIF and whoever is running eCitizen. So while we have done that part on making sure that there is that provision on access codes, we still have the work to do in making sure that now that part is implemented. And for example, these public agencies like NHIF publish their access codes. And just to highlight something Cynthia and also Daktari have said, is this issue of business and human rights. Even when the public agency can be slow, it is important to follow the business that is involved. There's always a company that is involved, and that company, sometimes you can follow them through the investors and raise awareness with the investors that the company is not doing right. So it can be through investors, it can be through taking that company to court. And there are a few cases in Kenya where companies are being taken to court. It can also be in following the money, as happened with the case of the convenience fee. I don't know whether it was concluded, but a while back, there was that whole hula baloo about this convenience fee that people are being charged, who's actually taking it. Those are some of the approaches off the top of my head. But by the time we're having a one-on-one after the panel, I think we'll have others that we can discuss.
Okay, so there's a question here, how to join the data privacy and governance professional society. If you write an email of interest to dataprivacyke as one word at gmail.com. So dataprivacyke at gmail.com, dataprivacyke as one word. Somebody will get back to you.
Well, we have come to the end of this panel discussion. Thank you so much for joining us. I hope this has been useful for you. I hope it has been a good use of your time. I hope you've learned something. And thank you for being here and giving us your time. See you on the internet. Thank you.